I'm not going to continue to play this game with you. Mr. Castro, I'm not doing this again.
Sir.
Look at me.
Sir.
I have people that continue to come back over and over and over, and all they...
Sorry.
I want you to look at me, because this is going to be a life-changing moment for you right now. They keep coming back. They keep pleading guilty. They keep coming back. They keep pleading guilty. It's a revolving door.
Okay, pause. This is not just a routine plea hearing anymore. When a judge says, "The door stops today," that's courtroom code for, "I'm done watching you recycle through my docket." 12 cases in a few years, that's not bad luck. That's a pattern. And legally speaking, patterns matter. Because once offenses stack up, prosecutors can enhance charges, meaning what used to be days in jail can suddenly become years in prison. So here's the question. Is this tough love? Or is this the last warning before the hammer drops?
The door stops today. Do you understand?
Yes, sir.
Yes.
If you are unable
Sir.
to not pick up cases, then we are going to delve deep next time as to why it continues to happen. If that means putting you in a rehab facility, in a dual diagnosis residential facility for figuring out mentally why these things keep happening, then so be it. The door stops today.
Yes, sir. Yes, sir.
Do you understand, Mr. Castro? I know you well. And in the last 2 to 3 years, we're working at least since you and I have been together. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 stops today. If you are unable to exercise self-control, we are going to dance a lot together next time. Do you hear me?
Yes, sir. Yes, sir.
Hear me loud and hear me clear, Mr. Castro, because I'm not doing this again.
Yes, sir.
We will have issues next time. Do you understand?
Yes, sir. I do. Yes.
You now stand charged with theft. How many is this anyways? Is the next one?
This right here is the legal turning point. The judge is explaining enhancement stacking, when repeated misdemeanors can be bundled into a felony. And once you cross that felony line, entirely different world, different sentencing range, different consequences, different future. And notice something important. The judge is actually advising him before it happens. That's rare. Most defendants don't realize they've triggered enhancement until they're already staring at a prison range. So ask yourself, if someone warned you this clearly, would you finally change course?
A felony regardless?
I don't believe so, Judge.
We should leave
Actually,
hard tests, Judge.
You run an NCIC for me, please, Morgan. Let's take a look to see. I want to advise him properly as to, you need to understand that every time you plead guilty to an offense, it goes on your record.
Sir.
And when you pick up a certain type of offense consecutively and times, they can put it together and they can file a felony case on you, and you're looking at years instead of days. You now stand charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. They've offered you 6 days in jail credit for the 2. Any prior thefts, Morgan?
no, Judge, I'm not seeing any.
You were giving up a lot of rights by entering into this agreement.
sir.
You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Mr. Castro,
Sir.
I want the best thing for you, but it continues to happen. So somehow we're not getting through to you. And we need to get through to you so that you understand it's not okay to continue to pick up criminal cases. And in the few short years you and I have been together, we're now working 12 cases. This is not acceptable. What do we need to do to get it to stop?
Yes. But yes, I'm completely capable of these, and because it is so highly agreeable, so I'm on top of it myself as much as I would be able to. This place, it is interestingly confusing, but yes.
Well, let me tell you something. I have a couple people in here that have continued to come back, and what we have done is now have them in facilities trying to figure out why they cannot stop picking up criminal cases. I'm telling you, I've got probably about 4 or 5 individuals that have kept with me. You now are on my list. So heed this warning.
Yes.
Do you understand, Mr. Castro?
Sir,
How do you plead to the offense of theft? Guilty or not guilty?
I'm guilty, sir.
And we'll find you guilty. I will sentence you to the agreement. Good luck to you, sir. All right, Josh. All right, Mr. McCollum, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just,
I'll do that.
it's okay. But just from now on, all right? So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for a first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was...
Well, it looks like the offense, so per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada, yada?
Whoa, that's a big legal moment. No probable cause means the state didn't meet the minimum burden to show a crime likely occurred, at least not with the evidence presented. And the judge zeroed in on something critical: timing. A terroristic threat has to create immediate fear. If there's no clear date, no clear immediacy, and no documented threat in the texts, the charge collapses. This is why details matter. Not vibes, not assumptions, evidence. But here's the twist: he's still on bond in another case. So even though he just dodged this one, he's walking on extremely thin ice.
Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. And not only that, it's not reported till 3 days later. Furthermore, in the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in offense report. report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm gonna find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm gonna do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not gonna go well. Life is way too short to live in a 6x9 box. There are a lot of great people in life. There's a lot of bad people in life. And if you have a relationship with a so-called person that brings out the worst in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure.
Morning, Judge.
He speaks both English and Spanish, Judge, but he says he may feel a little more comfortable in Spanish.
I don't know if it's going to be a good one, Mr. Martinez. I'm not happy with you. I asked you one thing. I have here that you're tampering with your device. Any alcohol detected?
No alcohol detected, Judge.
What do you know the?
Me?
But either. What?
So what he tells me in terms of the, I guess, potential tampering, he said was, the device was wet around his skin. So he used, in fact, he told me yesterday, he used a leaf blower to dry it off. That may have been one of the times it was tampering.
That would cause a tamper. Environmental factors like that don't cause something like that, and that would be such a short period of time. I have the durations of the hours on that little sticky note, and I can't remember them off the top of my head. But tampers are confirmed after 8 hours with no alcohol detected, so therefore a leaf blower wouldn't. If anything, it would show a spike in tamper, but nothing to cause a concern.
So what we have here, and what I have here, your first tamper was on October 28th, and it was in an 11-hour tamper. So more than likely, what we find is that people put things in between the scram device and their ankle to subvert the machine. Your second violation that we have is on November 11th at 3 in the morning, and that one is a 9-hour tamper. How does that happen?
I have a solution.
So, Judge, the only thing I have is the violation report. I don't have any other documentation from you guys showing exactly well.
The problem is that there's only,
But in terms of saying that it was for 11 hours.
I have the scram report.
but, and if you want to take time to look at it, but what we find, there's no cameras, so it's impossible to really look at what they're exactly doing, but all we know is that they're breaking the continual skin and device contact. And how they're doing that, I wouldn't know. Only he knows. But all we know is that the tamper is for a duration because the contact is lost somehow. Piece of paper, could be that they're using a sock, however it may be. But all we know, it's for a certain duration and that it's a tamper and it remains constant for that entire period. So the machine is not able to test his leg.
Okay, yeah.
So I'm happy to give you the device. You will stay with me now and take
I'd
a
like
look
to
and
look
tell
at
me
it and
what
talk
you
about
Yes.
exactly what.
Yeah, I mean, I'm not letting him go.
I understand. Okay, so
So
I'll get that and then
we'll give you the info now. I'm taking you into custody right now. I'll let you talk. I don't want him to go outside.
I understand. I understand.
But I'll give you more than enough time to talk.
Sure, okay. Okay, we'll talk afterwards.
Yep.
All right. Sure, MAA.
Good morning. I wanted to bring you out because there's things I would like to address with you. I don't know if at the time we ordered her not to consume alcohol or illegal drugs. Let me see.
This speech. This is courtroom psychology. The judge isn't just revoking bond, she's diagnosing a pattern. And legally, once someone violates bond conditions, especially by picking up new felonies, the court can absolutely tighten the screws. Higher bond. No PR. Stricter monitoring. But underneath the humor about rainbows and horns, there's something serious here: addiction mitigation. Courts do consider treatment. They do consider background. The tension is this: how many chances is too many chances? At what point does public safety outweigh rehabilitation?
One of the things that I ordered you to do was not have any contact with a Ronnie Boo Slyman.
Yeah.
And I see now that you have picked up a continuous family violence felony case. You don't have to say anything. I'm just letting you know what's happening.
Okay.
Now, we asked you not to do several things, and you have now violated several conditions of our bond. One of those being, number one, we ordered you not to have any contact with this person, and allegedly you've picked up now a felony assault against this person. You picked up a felony violation of a bond condition or protective order, and you also have picked up a felony assault against a peace officer. Because of this, I'm going to now revoke the bond here that you have here, and I'm going to raise it up. I'm not going to give you a PR bond when you continue to violate conditions. I'm going to do everything in my power to protect my public at all costs. And I'm going to tell you now, there are certain people in this life, when they consume alcohol, they become funny people. They have fun, they laugh like little rainbows, gumdrops, gummy bears, and little bunnies jumping in the woods. And there are those, when they consume alcohol, they develop horns, they develop they become the antithesis of what a person should be. And if alcohol has this kind of effect, don't use, because that may very well be the source of all these issues. I don't know, but I'm taking a stab.
Judge,
And I hope not.
if I may, Judge, just to let the court know, since she's been on bond conditions, she did voluntarily check herself into treatment for alcohol. So as the court knows, that the road to recovery is long and bumpy. She's in a difficult situation, being that she's originally from Mongolia. Is that right?
No, Kazakhstan.
Kazakhstan. I'm sorry, Kazakhstan. She had a pretty crazy story about getting here. This guy that the court told her to stay away from, is like one of her only connections, and he's also done some inducement to get her back over there. I understand that it was ordered for her to stay away from him, but it makes it difficult when you don't really have a lot of people to rely on, and then you have someone who's trying to basically get you to hang out with them, even though they know that it's been ordered that she shouldn't. But I just want to let the court know that she is taking steps to try to better herself and her situation. It's just she's in a difficult spot between the addiction and lack of resources.
Even if that's the case, if you know that alcohol has this effect and it brings out the worst, then don't. You already have an open case, and if you have no one to rely on in this world, if you go to jail, they're not going to bond you out, then you have to think of these things when you're out there. Because sometimes, you may have but 1/10 of a second to think, oh God, if I do this, what's going to happen? If I say this, what's going to happen? Now, where are we?
Can I say something?
It's now, anything you tell me, it's going to go in this ear and it's going to go out that ear, because I know
I got you.
if I let you out, you're still going to do whatever you want to do. You don't care what we say. That's the problem. And when you come here and when we talk to you initially, we try to tell you, look, this is how we expect you to act. This is what we expect you to do. And when you do, and when you show up to court, and when you talk with Hunter, good things happen. Now, I'm telling you this for the future because I don't know what's going to happen from here on out. All I know is that you have very serious cases upstairs. And in the future, going forward, whatever may happen, whether it's a probation, whether it's this, think before you act. And if the source and the root of all evil is, no matter how bad the addiction is, if you don't, it only gets worse. It never gets better. And the older you get, the more difficult life becomes. You get older, bigger, fatter, you lose hair, life doesn't get easier. And when you get more of this, so I hope that you take the help that is offered now, because we're going to offer you help, and we want the best to come out of you, right? We want the best for you. But you can't continue like this. So now, like I told Hunter, I am going to revoke your bond. I'm going to raise it up to $5,001. We'll come back in a couple weeks and see how we go forward, but I can't give you a PR bond when you pick up 3 felonies.
Judge, may I make an argument for bond amount?
Sure.
She currently has bond amounts on her felonies that she can't afford. She's indigent. That's evidenced by the fact that I was appointed to her, and also given a little bit of her background, she's not only indigent, but she's has a lack of resources otherwise. I would ask the court to consider $250 bond.
Gotta love you, Hunter. Gotta love you.
Just taking
the
into
bond's at
account.
$2,500 now, so that would mean lowering the bond. I'm going to set it at $5,001. We'll go forward. It looks like your felony case is set for February. You will go to felony court in February. Hopefully, you guys can wrap this up and try to get everything quick so you don't just sit there and linger.
Just ask for a speedy trial date on this case.
Absolutely. I have to give them at least 30 days for them to get all their stuff in preparation. Is it your case? Is it
It's actually Conrad's.
Conrad's? Yeah. Okay. I guess let's do this. Is he here? You want to talk to him?
Not by, but I can give him a call, maybe.
No, but I want to give him a head, or if you can give him a heads up that's where we're at. I guess let's set it for early next week. Is discovery complete in the case? Wait till at least we have some discovery first.
I think it's all complete.
I think we're still waiting on body cam. Let me see there. Yeah, it looks like this looks like body cam was re-requested.
We don't even have body cam. Let's do this. Let's set it for next week, like late next week. See if we can get the body cam. If you can get it, and then we can get also Conrad to come approach, and then we can set it at that time if you want. Yeah?
Okay, Judge.
All right. We wish you the best of luck, man. Take care. Mr. Williams, you are charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 9 days in jail with credit for the 19 days that you've done. I want you to understand that this behavior is just unacceptable, and And I'm serious when I mean that.
And this is modern reality colliding with criminal law. The judge is basically saying, Uber exists, Lyft exists, there is no excuse anymore. And legally, DWI enhancements escalate fast. First offense, misdemeanor. Second, harsher penalties. Third, felony territory. But here's the real kicker. Once you have that prior conviction on your record, every future traffic stop becomes magnified. Officers see it. Prosecutors see it. Judges remember it. So the question becomes, is saving $30 worth risking thousands in fines and your freedom?
Here, we're about accountability. And if I don't hold you accountable, I'm telling you it's okay and that you can just continue to run amok and just and railroad. And it's not. We mean business. We're here to not only protect the community, but to teach you a lesson so that you understand that it can't continue, right? I don't know what happened over there. I don't need, but when you're on bond, you can't pick up a felony case, and there are consequences, and I hope that you get it, right? The other thing that you need to get also now is that this will reflect as a conviction on your record. If you're ever in a car, I don't care where you are, I don't care what state you're in, you get pulled over and you have a smell of anything funky, they're gonna probably take you in. They see that you have a prior DWI, if it walks like a duck and it talks like a duck. So if I were you, I would never, ever get into a car, even if you've had a sip of alcohol, a toke off of a joint, you smell anything funky, I'm telling you, you're gonna go down. And what we're doing today, from now on, you're facing a minimum of 30 days in jail. So like I'm saying, I'm doing this, believe it or not, to help you. Because we want to see the best in you. We want the best from you. Be better, do better. You know, you're giving up the right to a trial, right to compel witnesses, testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal once you accept this agreement. You can never change this or undo this. It will go on your record. It will be there forever. I have to suspend your license. I am going to suspend it for 180 days. There is also a mandatory suspension, a DPS surcharge. I will waive that for you now. But I want you to understand that if you come back a second offense, you're looking at a minimum of $6,000 in fines and fees, not to mention another court cost of around $600 to $700. So if you pick up another DWI, not only is a minimum 30 days, but you're looking at probably around $7,000 in fines and fees. Just one button on this phone, $30. Wherever you want to go in this, don't matter where you want to go. That's what you need to do. How do you plead to the offense? Guilty or not guilty? I'll find you guilty. I will sentence you to it. You're going to walk out of here. You're not going to owe anything. But don't come back. All right. Thank you, counsel. All right, guys. Good luck. Yes, sir. Yeah, thanks. Yeah.
Okay, dramatic phrasing
One
aside,
button
here's what's
on this
happening
phone.
legally. When someone picks up a new
$30.
violent
Wherever
felony
you wanna
while
go in
already
this,
charged
don't
in
matter
another
where you wanna
assault
go.
case, judges can
That's what you
reassess
need to
bond
do.
based on community safety.
How do you plead to the offense?
That's
Guilty or not guilty?
constitutional authority.
I'll
And in
find you
Texas,
guilty. I will sentence you
especially
to
with
it.
family violence findings,
You're going to walk out of here.
enhancement
You're not going
risks
to owe
are
anything.
very real.
But
Notice the
don't come
immediate
back.
drug testing order
All
2.
right.
That's
Thank you,
proactive
counsel. All right,
supervision.
guys. Good luck.
The court is building a
Yes, sir.
record.
Yeah,
This is the shift from
Yeah.
warnings to control. At this
I've got
point,
a
do you think the
off-docket
system
matter.
is trying to
Okay,
save him
what you got?
or protect
It is
everyone else from him?
Offense, meaning you continue to pick up those cases. At some point, they'll hit you with a felony on that as well. Do you understand? So from now on, you're facing a minimum of 90 days in any misdemeanor court here in the state of Texas. Any misdemeanor you pick up, it's a minimum of 90 days in jail. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you accept this agreement, there's no turning around. This is stuck. It'll be there forever. Is this what you want to do? So you also need to understand that if you're on parole, pleading guilty to both of these cases, they may revoke your parole, sending you back to prison. What is ISF? I don't know what's going to happen, but they can revoke your parole, send you back to prison. Do you understand?
Yes, sir.
You still want to do all this? How do you plead to the assault and the burglary of a motor vehicle? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will sentence you to both cases. I'm going to roll your court costs so you won't owe anything. Good luck to you, Mr. Glover. Thanks, Will.
Thanks, Judge.
Yeah, so we have Jose Guerrero. This is an old case. It's from 2020.
You have another Guerrero?
Yes, I do.
Okay.
So it's an old case. It's from 2023. The state wanted a 30-day reset to look over the case to see.
It was a 2B warrant, Judge.
Okay. Is discovery complete on the case?
It said the 911 call is still in progress. It was requested on the 14th, but I mean, if it's from 2023, I don't know if they would still have records of 911.
Yeah, I think they keep them. What is?
Oh wait, no, that's on the phone. I apologize. Yes, discovery is completed. Besides, we need to subpoena for the medical records.
Do you have an offer in the case?
No offer yet because this case just came onto my docket, so I'm trying to reach out to the complainant to see if I can get in contact with him first before I make any offer.
Okay. So he's really just, it's been in,
Yes. The first setting on this case was on January 13th, 2025.
yeah, so they filed a 2B December of 23. And looks like he didn't get picked up until, January of this year. So we'll just give you like a normal, just, right. So it's like, how long have you been on it? Did you just get appointed?
Yes, well, I've been on since the January
Do like
setting.
settings. I mean, you don't have to just have 30 days. Well, normal because it's been in just a 2 week.
Thank you, Judge.
Okay.
Back on Jose Guerrero, do you have any other bond conditions aside from the ones from the magistrate?
Is this the one that we revoked?
No, that was Guadalupe Guerrero. Well, Jose Guerrero, we were just talking about if that was the 2B.
He's in jail?
No, he's here.
Come up, Jose Guerrero. So he has a felony assault from January,
Yes.
and then our assault here. Let's do PC because I don't remember anything.
Okay.
Mr. Guerrero, you are charged with assault causing bodily injury. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On June 14th, 2023, an officer was dispatched to a residence in reference to an assault call for service. The complainant entered into a storefront to make the report. The officer identified the complainant by his Honduras identification card. The complainant stated that he and his family were at their residence in Houston, Harris County, Texas on June 10th, 2023. And he stated that some friends later identified as the defendant came over to the residence to discuss the complainant working at their residence located in Cleveland, Texas. The complainant described the defendant to be in his mid-20s to early 30s, and they were all sitting around, and Ms. Bougon asked the complainant if they could drink while they ate. The complainant did not have any issues saying yes to the request. Then Ms. Bougon then asked the complainant if he could play music while they ate, drank beer, and talked. The complainant stated that while he was looking down at his phone attempting to start playing music, the complainant's son, Jose, struck him in the face with his left side, causing it to be swollen. The complainant stated he believed it was a close fist punch, but was not sure due to him looking at the ground at his phone. After the defendant struck the complainant, all three parties left the premises.
The complainant stated that after the altercation on June 11th, 2023, he felt pain and discomfort in his mouth and thought it was a broken tooth, but the pain got increasingly worse, where he felt like he needed to go to the emergency room. The complainant went to the hospital at a later date and then called officers on 213.
Okay, so what happened in the felony case then, please?
Yes. So on January 12th, 2025, an officer met with the complainant who stated her boyfriend began going through her phone and accused her of cheating. The defendant grabbed the complainant by her arms and squeezed them, causing pain. The defendant then punched her in the face and threw her to the floor. The defendant then stomped on the complainant's head several times, causing pain and for her to bleed from both ears.
Mr. Guerrero, I'm going to find that there's sufficient probable cause to go forward with your case. I'm going to do everything in my power to protect every person of Harris County. Do you understand? If I find that you become a danger in any way whatsoever, I'm going to make your bond so high you're going to have teeth falling out. Do you understand? You are not to consume alcohol, illegal drugs, unprescribed controlled medication, and I'm going to test you like crazy. In fact, I'm going to send you for a drug test right now. Do you understand? If I find that you're using, it's really not going to go well for you. You're not to have any contact with the complaining witness in this case, not to go where they live, where they work, anywhere. Can you run his license, see if he has a valid Texas driver license? Submission.
It says that, oh wait. It says, his CDL is
Cortez?
licensed.
If you do not have a Texas driver license and or liability insurance in your name, you are also not allowed to drive. Do you understand? Okay, so I'm sending him for a drug test now. If you fail to go test, if you fail to come back, a warrant for your arrest will issue. Take the test, you must come back. Okay, take a seat for me.